My name is Bill Brush, and I'm the president and founder of Cut Unnecessary Regulatory Burden. On the 20th of April, C.U.R.B filed a formal complaint with the Federal Energy Commission against Appalachian Power Company and the FERC. The complaint is an extensive complaint. It's 27 pages in length, and with attachments, it's 157 pages. So the purpose of this briefing is to try to summarize this complaint for those that don't want to read 157 pages. Let's first review what was going on in this project prior to 1998. APCO purchased flowage rights for the purpose of constructing and operating and maintaining the dams and associated power stations in 1960. They were granted flowage rights and the right to clear anything in that easement that would affect their ability to flood or operate and maintain the project. The landowner grantors retained the right to possess and to exercise their rights as fee simple owners that were unaffected by this flowage right. APCO also, during this period of time, was an active real estate speculator. It resold shoreline lands that it either had condemned or purchased during the construction of the project. APCO even went further and assembled, through purchase, large tracts of shoreline land that it sold to developers as waterfront property in the 1970s, in the 1980s, and up until 2001. They made millions speculating on this property because they bought it inexpensively and resold it as the project was developed and expanded. What was the common practice that APCO followed prior to 1998? Well, they didn't restrict any use of the shoreline because the flowage easement document granted owners, fee simple owners, to use that land for access to the waters of Smith Mountain Lake for recreational purposes and any use that did not interfere with APCO's ability to flood or operate the project. So consequently, shoreline owners were able to clear and plant vegetation. They erected fences. They paved pathways and roadways to the project. They graded and landscaped. They installed beaches and boat ramps, septic systems, water pumps, wells. They built seawalls and bulkheads, erected decks, gazebos, even built homes over the water. A condo building at Vista Point was built over the water of Smith Mountain Lake. Swimming pools, golf courses, restaurants, and a roadway was even constructed to access Contempt Island in the 1980s, a causeway across the lake. No part of the 1960 flowage easement deed required any adherence to a federal license or a shoreline management plan, and APCO only began issuing permits and revocable licenses to shoreline property owners after February 1998, when the FERC required them to implement Article 41 for land use and development within the project boundary. Well, let's discuss what the key elements of our complaint are. First, we do not believe that Appalachian holds the necessary state property rights to meet its license obligations. They refuse to address these property rights in state court, instead drag violators into federal court, and that's a violation of what FERC has told them to do. FERC also failed to require APCO to fully and accurately disclose its property interests, and we believe FERC is complicit in the unlawful taking of property here at Smith Mountain Lake because they failed to monitor APCO's permitting process, and they've even gone so far as to make materially false statements regarding what they believe APCO's property interests are. APCO certified with their drawings that they hold all flowage rights necessary for adequate operation of the project, either in fee simple, title, or in easements. Well, that's simply not true. First of all, it conflicts with previous drawing submittals that Appalachian had made in 1967 and again in 2004. It conflicts with Virginia state property law. These 3 Supreme Court cases that we've talked about in the past still pertain here and clearly show that Appalachian really only has a flowage easement and that the fee simple owner of the land or the grantor of the land has the right to access the lake for recreational purposes and use those lands for any purpose they want, so long as it doesn't interfere with APCO's ability to flood and operate the project. Furthermore, it even conflicts with the historical record of Appalachian statements and newspaper articles over the course of time. Appalachian was required to certify within 5 years from the date of its license, which was most recently awarded in 2010, April 1st. They were supposed to either acquire lands in fee or the right to use in perpetuity all lands necessary and appropriate for the construction, maintenance, and operation of the project. They failed to do that. APCO submitted non-compliant Exhibit G project drawings. Is this a big deal? It absolutely is, because these are the drawings that define where the project boundary is and who owns what. Their drawings fail to identify project lands by subdivision. They fail to identify what lands APCO owns in fee, those lands APCO only holds flowage rights for, those lands that are privately owned by other individuals, and any lands that Appalachian plans to acquire in fee or easement or lease, if there's any of those. This is an example drawing from Appalachian's Exhibit G drawing submittal. This is sheet 8 of 16. You can examine this drawing and you'll see very clearly that there is nothing on this drawing that shows any subdivision of land or any ownership rights. Compare that now to First Light Energy's drawings, which were resubmitted recently under FERC order at Candlewood Lake. You can see subdivisions of land here. You can see flowage easements. You can see notes. This is what the drawings are supposed to look like and are supposed to comply with. FERC accepted Appalachian's drawings, which are non-compliant, and that's part of the problem because FERC has no way of knowing who owns what in Smith Mountain Lake. APCO continues to avoid resolution of property disputes in state court in violation of FERC direction and order. Most recently, in 2014, the power company filed a lawsuit against William Nissen in the Western District Court of Virginia. Worse than that, they filed this court action in violation of FERC orders and guidance. They even bypassed the approved FERC SMP violation notification process. Appalachian's SMP and their practice is to notify a property owner of a violation prior to filing a lawsuit to give the property owner adequate time to either respond to the violation notice or correct the violation if there is one. By doing so and avoiding this notification process, they actually subverted Nissen's rights of access to state court for proper adjudication of property disputes. FERC continues to ignore property rights. They do so because they say the Federal Power Act gives them no authority to adjudicate property rights. That's true, but it doesn't absolve them of their responsibility and their obligation under the FPA to ensure when they award a license that the licensee has those property rights necessary to implement the license. Their records from 1967 and 2004 drawing submittals from Appalachian Power clearly show that Appalachian has very limited flowage rights in this project, insufficient to implement its license. License Article 5 requires the licensee to obtain sufficient property rights within 5 years from the award of a license. Well, this latest license was awarded on 1 April 2010. It's been more than 5 years, and FERC has done nothing to ensure that Appalachian has effectively obtained those property rights. And by not doing that, they've really denied shoreline property owners basic due process. FERC continues to fail to police its licensees and the licensee's permitting process, even though numerous stakeholders have complained about the inadequacy of Appalachian's property rights and the draconian measures that the permit imposes upon these landowners. FERC has gone so far as to misrepresent facts regarding ownership in this project. FERC says they can't adjudicate property rights, but nothing absolves them of their responsibility to ensure that their statements are factually accurate. Because the reservoir is owned by the company, which it is not, landowners must obtain permission from Appalachian Power for any private uses. Not true. Landowners have flowage rights. They granted Appalachian the ability to flood a portion of their land, and in exchange for that, they got the right to use that property in any manner whatsoever, so long as it didn't interfere with Appalachian's flowage rights. As the Commission explained under the original SMP proceedings, private access and docking facilities are privileges. No, not true. They're not privileges if you have deeded rights for those. It appears that several adjacent landowners own property with certain deeded rights that allow the landowner to access the reservoir for recreational purposes, and that such uses are to be made under a revocable license. Well, that doesn't make any sense whatsoever. How do you have a deeded right that can be revoked at any time? That's not what the flowage easement says. That's not what is true. So here again, 3 statements made in 2014 where FERC misrepresented facts of ownership and told all stakeholders that Appalachian has the right to do this. They have no authority to do this, and that's a violation of the Federal Power Act. FERC's misrepresentations allow Appalachian to continue to take private property without compensation. They use their permits to extort owners into agreeing with the permit. Under threat of federal litigation, APCO claims they have property rights they do not hold, and they even go so far as to say the FERC gave them federal authority to do this, none of which is true. The permit actually takes a permanent right, property right, deeded right, and converts it into a revocable right without paying for the taking of that property. Such action violates the U.S. Constitution's 5th and 14th Amendments regarding takings and Virginia's Constitution. In our complaint, we also point out that an inherent conflict of interest exists within the Office of Energy Projects. In that same office, licenses are negotiated and awarded, license fees are collected, and regulation occurs post-license. C.U.R.B fights for property rights while FERC pleases licensees because APCO's license fees pay FERC's salaries. I couldn't have said it any briefer. This is what C.U.R.B has requested for its resolution of this complaint. First of all, we're asking that APCO be required to submit accurate project drawings and to revise its Article 5 certification accordingly. We also ask that APCO disclose all encroachments. Encroachments are considered unpermitted uses within the project boundary. All those encroachments that were in existence prior to the award of the first Shoreline Management Plan order in July 2005. That'll be interesting because that encroachment order will identify all the docks, all the marinas, Vista Point condominiums, and all other encroachments within the project boundary that have never been disclosed to the FERC before. This is very consistent with what's happened at Lake of the Ozarks and also at Candlewood Lake in Connecticut. We've asked that APCO be made to invalidate those permits that it extorted from shoreline property owners, and we're asking that the Commission exempt those lands that APCO does not hold the necessary property rights for from shoreline management, because that's what the rules say. If you don't have the property rights, the Commission has no authority to regulate privately owned property. And we're asking that the Commission require the Smith Mountain Lake project licensee, Appalachian, to coordinate in the future with state and local governments and the resource agencies to help regulate project lands. Filing a formal complaint with the Commission is the equivalent of filing a lawsuit. So this process becomes quite formal. FERC will issue a notice of this complaint, and it will solicit answers, motions to intervene, and comments. That allows stakeholders and supporters of C.U.R.B to either intervene in this process and become part of the solution, or to simply comment on the complaint. This is normally open for approximately 30 days. We'll notify you when this 30-day window opens, and also advise you how you can make comments to the FERC as simply as sending an email. The complaint could be resolved by ADR, or alternative dispute resolution, but in order for that to happen, both the power company and FERC would have to agree to this. The Commission could also issue an order after reading the complaint and saying, yes, this is what we need to do. We don't know if that's even a reality, but it's a possibility. The Commission could also establish a hearing before one of their administrative law judges to try to resolve this. If we're dissatisfied with the processing of this complaint or its outcome, we have the right then to file an appeal in the D.C. Circuit Court of Appeals. This is the same court that recently determined that it was illegal for a government agency or a government to issue regulatory authority to a private corporation. So here we are at the end again, working to save our property rights here at Smith Mountain Lake. We need support from our community in the form of financial donations. Our mission is to educate and inform our citizens and a community of the importance of property rights. Your financial contributions go to support the ongoing litigation and the ongoing education within our community. So please continue to support C.U.R.B with financial donations to save your property rights. Thank you.